Morning.
Morning, Your Honor.
All right. We're set here in the matter of Ankh versus Stephen Reeves in the Marion County Treasurer's Office. I see Mr. Ankh here in person. I see Ms. Kessler here representing.
Morning.
Morning, Your Honor.
All right. We're set here in the matter of Ankh versus Stephen Reeves in the Marion County Treasurer's Office. I see Mr. Ankh here in person. I see Ms. Kessler here representing Mr. Reeves and the treasurer. We also have one more person on. Is it Mr. Seidel?
That's our intern.
Oh, never mind. I should know who he is.
Honor, just to clarify, I do not represent Mr. Reeves, just the city of
Just the
Indianapolis and the
just the
treasurer's
city of
office.
Indiana and the treasurer's office.
Yeah.
Okay. All right then. Why don't we go ahead and proceed? There's competing motions for summary judgment. The first one was filed by Mr. Ankel, and then there was about a month later a motion for summary judgment in response to Mr. Ankel's summary judgment was filed by the city and the treasurer's office. Mr. Ankel, can I'm going to put myself on mute and I'm going to let you start off with the arguments and then we'll hear from the other side. So you may proceed.
Okay. Well, basically, I would like to remind. I want to first start out with the fact that, and I'm just basically going to read what I said in my response to their summary judgment. The defendant has failed to raise or show any material issues in response, in opposition, or its motion for summary judgment. Defendant's response and motion are merely a request for summary judgment with no argument in either the motion or the defendant's memorandum of brief. Therefore, as the defendant has not issued an argument against what I've said in my motion and memorandum, the undisputed facts must be taken as follows. Under IC 26-1-1-201, Section 11, the registration form for the auction is a contract. My signature on the contract also bound the defendant to the rules of the auction. If I buy a house, they are bound to give me the deed to the house. If I buy the house in the proper manner, which it was paid for in the proper manner, they were bound to give me the deed to the house. The receipts, the thank you letter, the right of entry letter, exhibits A, F, and B show that I participated and properly paid for the parcel in accord with the auction rules on July 26, 2011. The defendant breached the contract by failing to provide me with a valid quitclaim deed in a timely manner after I paid for the parcel. Defendant knowingly defrauded me of my property by recording the affidavit and notice of quitclaim deed, which is Exhibit D, on September 20th, 2011, and then they voided the quitclaim deed and sent me the voided quitclaim deed on November the 1st, 2011, as if it was valid. Then they went back and sold the property to Stephen Reeves on March the 3rd. So the fact that they avoided it prior to and then sent it to me, that is an acknowledgement of fraud. They knew what they were doing. Hold on just a second. The defendant furthered the fraud by selling the property to Stephen Reeves on March 3rd, 2012, while on March 7th, 2012, sending the right to property notice, which is Exhibit D, to an unrelated address where I don't know where they got that address from, but I had not lived in that address for years. I had not used that address on any documentation in dealing with them. So I don't know why it was sent to that address, but in that notice, they said that I had committed fraud or that I had sent them fraudulent payments, whatever. Um, but the defendant can't provide anything from the bank. They can't provide anything that says that my payment was fraudulent. They have, it would make sense that if I did give them fraudulent checks or counterfeit checks or whatever, that they would have called IMPD on me and I would have been immediately arrested for counterfeiting or fraud. And those checks were used numerous times in Marion County, the clerk's office, all over the place, and I have no fraud. And with that, they showed a bank statement that it was heavily redacted, but it just showed chargebacks, and the chargebacks were for the amount of the checks that I had given them. So now there's no reason for the chargebacks. They haven't given anything, they haven't provided anything from the bank to give reason. So they failed to enforce their right of payment. And that's also in Indiana's code, where, if the bank wrongs you, you have a right to payment. You have to enforce that. So if they did not enforce their right to payment, I cannot be penalized for them not doing what Indiana code says that they are supposed to do in this situation. On top of the fact that they sent the notice to another address. So that, for me, that tells me that you were trying to cover up an act, because I had never seen that notice until Ms. Kessler provided it in the discovery. I'd never seen that. So, no, I'm sorry. Wait a minute. Hold on. Let me take that back. No, because we went through a lot of back and forth, and they were actually sending documents to my actual address, which is where they sent the quitclaim deed and the other notices that we were going back and forth. They had my address. So, yeah, that was the one that I had not seen before. So, yeah, that would, the first notice that I had of Stephen Reeves even having the house was when he changed the locks on the doors. And he told me that, yeah, they came to me, they said your payment was fraudulent, and they sold the house, because he's the next door neighbor. He lives right next door to the house. So the whole time from July to March, I had been working on the house. I had been fixing up the house. I had been cutting down trees, cutting down bushes. I had to clean the house out. I was actually working on the siding and the gutters when the locks were changed on me. And he said in his documentation, he said they told him that if I came to the house to call this particular number, well, that particular number turned out to be the police non-emergency number. So I tell the police to come, because we have a situation. So when when the police arrived, he showed them his documentation. I showed them my documentation. The officer said, period, I can't do anything about this because it appears that both of you own this house. That's what he told us, and he left it at that. And at that point, before I could start a proceeding like this, I lost my freedom. So now that I'm back, within that statute of limitations, that's what I'm here for. I'm here to claim my property that they stole.
All right. Thank you, Mr. Ankel. Ms. Kessler, you have the floor.
First, I would like the court to disregard pretty much everything that Ms. Kessler has said, because she had the opportunity to put that in a summary judgment, either rebuttal or a summary judgment brief in her motion for summary judgment. She didn't put any of that in there. All she sent were evidence or, exhibits. That's all she had with a motion for summary judgment. There was no argument. There was not anything provided with it. That's why I say at the beginning, she didn't provide any argument for me to rebut. So now in the hearing, they're trying to give a whole story, a whole argument, a whole situation. Oh, we don't have the records. They're not there. The record retention. But again, and you didn't provide a bank, if a check bounces, a bank has 3 days to protest that check. They have 3 days to protest that check. If in those 3 days the bank does not protest that check, the bank is responsible for that check. When I went back to the Treasurer's office September 1st, there was a whole month and days between the time that I had paid for the parcel. And then on September 1st, they showed me on the computer that it was my property, and they also gave me the right of entry letter that says, this is your property. You have the right to go into this property. So when all of these, the argument started was when they never sent me the deed. But then on the cash book entries, on the what exhibit is that? The Marion County Treasurer's Office cash book entries. Let me find this real quick. It says the bank charges counterfeit money order. It says counterfeit money order. There were no allegations of counterfeiting from the bank. That would mean someone would have to call the police on me for counterfeiting. No one called the police for counterfeiting. In fact, they tried to get Stephen Reeves to call the police on me like I was trespassing on a property that I had purchased. And the officer said, you both own the property. So, like I said, when I found, that was a total surprise. And everybody is saying that I gave them counterfeit money. They sent the notice of, I gave them counterfeit checks. They sent that notice to an unrelated address. There's no telling how they got, that address had not been used since 2006. That address had not been used on anything since 2006. So where they pulled that from, I have no idea, because they had my recent address. We were corresponding back and forth. They knew where to send the voided quitclaim deed. They said this all happened a whole month later, according to Indiana law. And I say this in my summary judgment, the bank has until midnight of the next banking day, the next business day. Excuse me, I said 3 days earlier, but they have till midnight of the next banking day to protest the checks or the payment. If they don't protest that, then they are responsible for it. So, again, there's no evidence anywhere that Marion County is saying counterfeit and fraudulent, the bank said chargeback. They didn't say insufficient funds. They said chargeback. Insufficient funds, that means that the checks were not cashed. They were rejected. Chargeback means that the funds were deposited into the account and then removed. There's a difference between insufficient funds and chargeback. It is illegal once they this is Indiana law again, this is Indiana's commercial law, and I believe this is all in my summary judgment brief and all of that. Once they accept those checks, once that check is electronically processed, they have to do it because the account is there on the checks. She said there was no account number. The account is there on the checks. So without the account number, the checks couldn't have been cashed. There would not have been any chargeback. That means that the money was deposited. So whatever happened, my quarrel isn't with the banks because I have the receipts that show that they were paid. They can't show me. My quarrel's with the Treasurer's office because they can't show me where I breached the contract. Yes, there was a chargeback, but that is from the bank. It doesn't say insufficient funds. It says chargeback. That is between the Treasurer's office and the bank. And again, the Treasurer's office said counterfeit. No one from the bank said counterfeit. No one from the bank said forgery. But every record that the Treasurer's office had, like the cash book entries, this isn't a bank entry. This is Marion County records. This isn't Huntington's Bank's record. This is Marion County's record. They put counterfeit money order. The notice that was sent to the Getz Lane, it said fraudulent. So where is the Treasurer's office is the only one that's saying fraudulent. They are the only ones that are saying fraudulent or counterfeit. And it looks like you were trying to avoid conflict because, as I stated, they tried to get Stephen Reeves to call the police on me. They gave him the non-emergency number because why they would do that, I have no idea, but that's what they did. And again, her whole entire argument should be disregarded because she didn't put any of that in their brief or their motion. All they sent.
Oh, go ahead. I'm sorry, I didn't mean to cut you off.
But well, yeah, I'm almost finished. That's all they sent were exhibits. They didn't have any argument, anything. Now she argues all of these things that they didn't say in anything. So according to the rules of summary judgments, as far as I know, your entire argument has to be in that summary judgment motion. They had no argument. In their response, they had no argument.
Hang on for 1 second. Hang on for 1 second. Mr. Ankh, are you finished?
Yes, sir.
All right. You want to clarify, Ms. Kessler?
I'm a little confused by Mr. Ankel saying that there was no brief filed because there was a brief filed and it was sent to him. Did Your Honor have the brief?
Yeah, I have the briefs. He mentioned something about argument. I guess maybe argument at today's hearing not being reflected in the briefs. That's what I interpreted that to be. But I've read all the briefs. I do have your brief and I do have his brief.
Okay. I just wanted to make sure that there wasn't some sort of error that I missed.
Oh no,
that's all I wanted. I
have all the briefs. So here's what I'm going to do. I think that I've heard everything that I need to hear. Anything else would be repetitive. Let me take it under advisement. We have a final pretrial set for August 20th. So what I would like to do is get you guys, if you could, I want proposed orders, not more argument. I want proposed orders like a judge would sign, not, I don't want, when I say additional briefing, I don't want to, there's your speak, there's my speak. So when you prepare order, prepare it as if I would sign it, right? And then you can put in there, the basis upon which, I should rule in your favor, that kind of thing. But just be mindful of the language. It's again, what a court would order. It's not an additional brief. Does that make sense to both of you guys?
Yes, sir.
Okay. We'll give you until August 15th, which is a Thursday. So that's about 3 weeks from now. It can basically be about the same size as your briefs. I don't need to, for this kind of case, I don't need anything over 8 pages. Okay. And then I will rule in advance of the August 20th final pretrial conference. So you'll know in advance, and it might be one day in advance, but you'll know if we're going to be having that pretrial conference or not, right? Based on how I rule. So with that being said, I'll close the proceedings out. I'll let you all get to work on your proposed orders. Go ahead and file those like you did with your briefs through the e-file system, and we'll figure this out. So thank you so much for your time. I appreciate your arguments as well.
Thank you.
Have a good morning.
You too.